It's Tuesday. It's September 30th. Let's go to Florida to talk about Donna. Donna. Y'all watch the Donna Adelson trial with me. We all watched that together. Donna Adelson is still pending sentencing. There's a hearing October 14th. We will watch that together. I'll end up moving stream to the afternoon. It might be a pretty quick status hearing. They have not set a sentencing date yet. However, after Donna Adelson's conviction on all 3 counts that she was faced with, which were murder, conspiracy to commit murder, solicitation of murder, on the murder charge, she is facing life, period. It's Florida. You don't even really need to say life without the possibility of parole, because in Florida, there is no parole. So just life, the end. So after Donna's conviction, the sentencing is statutory as to that. And then she can be sentenced, I believe it's up to 30 years on the other 2 counts. It is a life sentence plus the other things. The defense attorneys made their necessary and expected motions. These are not their appeal. These are before their appeal. So they made a motion for new trial. They made a motion for the judge to reconsider the judgment of acquittal. That was a fairly short motion that we didn't go over very much because it was, Your Honor, we asked for a judgment of acquittal and you said no, but what do you say now? Still no? Okay, thanks. The focus of our attention when looking at Donna Adelson's motion for new trial was a request to interview jurors in the motion for new trial, saying that one of the jurors, the 4-person, had posted about the case on TikTok. We went through the TikToks. And the 4-person said essentially, I'm on a jury. That sounds kind of lovely. Like, I don't have to go to work. I'm not at home with the kids. Like, I get to just go do jury duty. Seems great. And then after the case talked about serving as a juror, which they are allowed to do, different than a grand juror. Trial juries can talk about their experience on jury duty. They don't have to, but they can choose to. Big fan of choice over here. So they get to choose to do that. Donna Adelson's attorneys wanted to interview the jurors for reasons. And we went through that motion pretty thoroughly. And now we have the judge's response. And the judge immediately says in the filing, even in the docket, it says defense motion denied. Like, the docketing item starts with the ruling. But really, it's not the ruling that we are most interested in. We knew largely that this was going to be denied. What the judge would say was interesting to us, but we knew it was going to be denied. What I'm very interested in is the fact that this is 57 pages long, and the judge included a ton of excerpts from transcripts. Circuit in and for Leon County, Florida. Order denying defendant's post-trial motions. This cause came before the court for consideration of defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal, all filed September 15th. The court having reviewed the defendant's motion, the court file, trial record, and being duly advised in the premises, hereby finds. The state didn't respond, by the way, which is so strange to me, but the state just, there was no response. The court ordered their order before there was a response. I don't know if that's a Florida thing, but the court just ruled. The court was like, I got it. So those are the motions. Motion for new trial, renewed motion for judgment of acquittal, and the motion for leave to interview jurors. 3 things. Motion for leave to interview jurors. This is what I am the most interested in, like 100% the most interested in. Defendant seeks to interview 2 members of the jury in her case, jurors 5 and 7. In moving to interview jurors, the motion, quote, must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. I was looking for the standard. The defense never said it. And I kept saying, maybe the government will lay out the standard. Well, there it is. Consequently, quote, juror interviews are not permissible unless the moving party has made sworn allegations. What, court? Sworn allegations. Not conspiracy speculation, as Peter Mom would say. Sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. I've pronounced this improperly all of the time. As to vitiate the entire proceedings. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court. This is why the defense, speculation on my part, didn't put in the standard, because the standard would make their motion seem ridiculous on the face. So the defense never put in the standard for leave to interview jurors. And now that we see the standard, doesn't it just make their entire motion look insufficient on its face? Because yeah, in moving forward to interview jurors, they must set forth allegations that are not merely speculative, conclusory, or concern matters that adhere to the verdict itself. And the juror interviews are not permissible unless the moving party has made sworn allegations, meaning affidavits, that, if true, would require the court to order a new trial because the alleged error was so fundamental or prejudicial. And now the court is going to go and let us know exactly what the defense argued. The argued reason for interviewing juror number 5 is that he revealed he considered how defendant reacted to the evidence and testimony during trial. However, defendant also notes that juror number 5 expressly stated he did not consider her reactions during deliberations. The court said what we all said when we read this. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed defendant's reactions during trial. I love how the court just rephrased it. So he noticed your client's face. Okay. By operation of fundamental procedural and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for jurors to visually observe the defendant over the course of a trial. The Florida Supreme Court actually ruled on this in 2010 in Phillips versus State and found, quote, the fact that 3 jurors briefly viewed a defendant in his jail uniform was insufficient to warrant a new trial. The facts alleged here fall short of the argued prejudice found as insufficient in Phillips. So the court is saying in Phillips, the court found that the argument was insufficient, and this is even less than that. Accordingly, the defendant may not have leave to interview juror number 5. No interview for you. The argued reason for interviewing juror number 7 is that, quote, she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account. Your Honor. The court did our work for us. Remember, we pulled it up on TikTok and we were like, is this the post? Because the defense said we, on information and belief, were told that it was deleted. Judge Everett looked at what the defense said and then went on TikTok and found the same post still on the account, not deleted. Thanks, Judge Everett. And then he goes out and lines out exactly what was said in the TikTok. It's the one we thought that it was. You know, defense attorney Fulford wrote this for the defense, right? It had to have been. Defendant provided a video recording of the post, and the court was able to locate the post on the juror's TikTok account, where it remains an active post as of the filing of this order, not deleted. It displays the following text over a video of juror number 7, quote, when I told God I needed a break and he makes it so I'm selected to serve on a jury for a 2-week trial, won't he do it? Along with a caption that reads, quote, no work, no kids for most of the day. YK, what? Heaven. Yeah. She was like, so I don't have to go to work, but I'm also not home taking care of young kids. And I get to sit in a courtroom and have snackies and adult conversation and eat lunch with both hands if I want to. Read a book and watch what happens. Okay, let's go. A lot of you in the chat, you have 2 weeks off of work. You get paid by your work. You go hang out with Judge Everett. You have like an hour plus for lunch and you get to sit there and watch what plays out in court every day. Okay, sounds great. So there's a link to the TikTok. We watched this TikTok. We'll link it. It's timestamped in the other video where I covered this. The juror was instructed not to communicate with anyone, including your fellow jurors. Quote, the court said in italics about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. Attachment Exhibit A. The court concludes juror number 7's TikTok post does not constitute communication about the case. That's what we said too. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it was a civil or criminal case, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not, quote, so fundamental and prejudicial as to vitiate the entire proceedings. No, it was the comment of a working parent who said, I'm on jury duty for 2 weeks. I needed a bit of a timeout. This is a timeout. I love that the court addressed the insinuations made by the defense. The defense said that they thought that the TikTok was deleted. The court said it's not deleted. They said this is about the case. The court said it's not about the case. And the court responded to all of those allegations. It's not about the pasta. Furthermore, the court goes on, every prospective juror was informed, quote, if you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. That's needed information for everyone. However, you must not give anyone any information about the case itself or the people that are involved in the case. Attached B. These are transcripts. Defendant did not object to the jurors being able to disclose that limited information. You need to be able to tell your partner, the people in your life, your job, hey, I'm on jury duty. Hey, it's going to be 2 weeks. I mean, it could go over, but it's going to be at least 2 weeks. You need to be able to tell people that information. Defendant did not object to jurors being able to disclose that limited information, and juror number 7's TikTok post comports with this exception to the communication prohibition. Defendants cannot now use juror 7's compliance with this directive as grounds to interview her. Accordingly, defendant may not have leave to interview juror number 7. The motion for leave to interview jurors is denied as to both 5 and 7. Get out of here. All of you are like, can we tell your bestie? You can tell your bestie that you're on jury duty and for how long, and that you can't talk about the case till it's over. Motion for new trial and renewed motion for judgment of acquittal. We're on section A. Contrary to the law or the weight of the evidence and judgment of acquittal, the court does not find the jury's verdict is contrary to the law or the weight of the evidence. So the court is listing out the prongs of consideration. When considering a Rule 3.600A2 new trial motion based on the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports an acquittal. The court must weigh the evidence and determine credibility just as a juror would. The court concludes the greater amount of credible evidence supports the convictions. The court relies upon its previous rulings, all direct and circumstantial evidence admitted, the evidence demonstrating defendant's consciousness of guilt, and its own credibility determination of the witnesses. Stated succinctly, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. See Williams versus State. The court quotes that case as saying, at a minimum, there must be proof of some overt act or some words uttered in furtherance of a scheme that led to the murder. That was also expressed in the jury instructions. So that's going to the count 1, the murder. The court goes on to say the members of a conspiracy may have more than one objective, cites case law for that proposition. The trial evidence demonstrates defendant's objective for the crimes being committed as separate and distinct from her son, the middle woman, and the triggermen. However, their combined acts resulted in the crimes committed and death of the victim. So what Judge Everett is saying is, hey, Donna's motive and Charlie's motive may have been different. And then when you get to the go-between and the gunman or the triggerman, they might have been just simply motivated by money or a combination of other motives. They don't have to adopt the motive of Charlie and Donna, and Charlie and Donna's motive don't have to be the same. It can be that Charlie's motive is to take care of a problem for his mom, and it could be her motive is to get Dan Markel out of the way so that she can win. Or is it that these are my grandkids, they're going to come live with me and we're not going to fight over this anymore? It can be any of it, but the motives don't all have to be the same. The objectives don't all have to be the same. The court goes on to say, because the objective of certain co-conspirators was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payments. And then the court quotes United States versus Hickey from 1979. The trial evidence established defendant's connection to the payments. Thus, based on the unique facts of this murder for hire, defendant's case is distinguishable from Williams, which is the case that we're going to do a deeper dive into that the defense cited. The court also denies the renewed judgment for motion of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal, all direct and circumstantial evidence admitted, and evidence demonstrating defendant's consciousness of guilt. The court does not find error in refusing to admit the complete 2014 and 2023 planners. We talked about this in the motions. We saw this argued in court. The court saying, I'm not overruling myself, doesn't mean that this won't be part of what the defense goes on to argue at appeal. We are still at the trial court level. There will be an appeal in this case. Now, whether it's these defense attorneys or other defense attorneys to do that appeal, we will see. In Charlie Adelson's case, his trial attorneys did not do the appeal. And that's actually more common, that the defense attorneys from the trial level do not do the appeal. Now, we'll see if Donna can find an appellate attorney faster than Sarah Boone. I don't know if I'd want to put money on that. Who gets an appellate attorney quicker, Sarah Boone or Donna Adelson? Even if she pays for private counsel, if it's determined that she qualifies, she can have a public defender appointed for appeals who handles appellate cases. So the court is now going through past rulings, and the defense is asking for the court to change their mind on. How well does that ever go? Because the defense hasn't brought in any new information. The defense is just like, do you want to change your mind now? No? Okay. The court goes on to say, defendant asked to introduce the complete calendars during its case in chief. As an initial matter, the request was untimely. Oh boy. Counsel? Nah, it was untimely to start with. So even if you have an issue with my ruling, too bad, so sad, too late. So not the appropriate way to yeet a motion, but the motion was in fact yeeted. The defendant in this case, back to the motion for those of you listening, asked to introduce the complete calendars during its case in chief. As an initial matter, the request was untimely. Section 90.1081 of the Florida statutes says, quote, although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. So, to break that statute down a little bit more in plain language, the courts have held that if the defense brings it up during cross-examination, it is timely. It doesn't have to come up during direct examination. It goes on to say defendant's request was too late because it came after cross-examination of the relevant witness. Even if the request was timely, it was improper because the purpose of the rule of completeness, quote, is to avoid the potential for creating misleading impressions by taking statements out of context. By its very nature, a calendar day planner is divided into a series of pages corresponding with days in a year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. Interpreting the rule of completeness to allow for every other entry in the calendars, quote, would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of section 90.1081, quote, fairness does not require turning the trial into a voyage on a sea of hearsay. Who wrote that, Your Honor? Your Honor! I love it when the appellate courts have a little fun with their writing. How annoyed was this appellate judge in Carter versus State from 2017 that they wrote that fairness does not require turning a trial into a voyage on a sea of hearsay. Oh, it's so great. For any law nerds out there that want it, that's Carter versus State, 226 SO 3rd 268 at 272 Florida 4th DCA 2017. Accordingly, the defendant's invocation of the rule of completeness was properly denied. The court does not find the arguments presented in this claim warrant a new trial. Specifically addressing defendant's decision not to testify, the court relies on the trial record. Remember, Donna was just like, hey, I didn't have enough time to decide. This is going to come up in appeal. We know it's going to come up on appeal. This is the court's response to it. Specifically addressing defendant's decision not to testify, the court relies on the trial record. Oh, there's attachments. This is the transcripts. After defendant had closed her case, but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. The court explained it had performed additional research and wanted to confirm that defendant did not want to testify. Really? Before closing arguments, this conversation was happening. The court explained it had performed additional research and wanted to confirm that defendant did not want to testify. The court added, quote, the reason why I am bringing this issue to the party's attention is only because I believe the appellate case of this state, or the appellate cases of this state, makes clear prior to instructions in closing The exercise of the fundamental right leans towards allowing the defendant to reopen her case if she wanted to testify. Attachment C at 6, footnote 1. The court also clarified its reference to contempt was related to the defense counsel not timely returning from their conferral with defendant the previous day after being instructed they had, quote, exactly 5 minutes to discuss defendant's decision not to testify. Attachment C at 5, attachment D at 25. Oh, now we're getting all the tea on the contempt statement, which has to do with
why is no one ready?
Defendant and counsel did not seek any additional clarification on this matter. For additional context, the court attaches a compilation of the discussions concerning defendant's decision not to testify that precipitated the court's warning, including when the court mentioned that, quote, whether the direct examination will start this afternoon is a separate matter from whether she is planning to testify. Attachment D at 22. A compilation of excerpts from sidebar conversations? Yes, please. Also, Donna didn't want to testify. One of Donna's best attempts in this case was to not testify. I love that he's like, what we're not going to do is play with me. I'm going to tell you everything. And the court is going to line out his record on what he said to her. Upon the court's inquiry, counsel responded, quote, we talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Miss Fulford and my paralegal that she felt secure in her decision. If I am the judge and you send me an entire motion saying, but Your Honor, but Your Honor, but Your Honor, and then I know that it's sidebar, you told me the exact opposite, I'm also gonna lose my mind. This judge was so patient. And he's like, oh, would you like me to explain it to you? Let me explain it to you. Then I accept your invitation. Donna informed Miss Fulford and the paralegal that was sitting next to her, like holding her shoulder the whole time, that she felt secure in her decision. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. The court then granted an additional 30 minutes to further discuss her decision. Was this why they were so late? After that time had elapsed, the defendant once again stated, I have made a decision. I am not going to testify. Because we didn't see this. This was before closing arguments started. When asked if she was firm on this decision, defendant answered, I am. Attachment C at 11. The court concluded, quote, I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. Attachment C at 11. Neither party did. Accordingly, defendant was provided sufficient time to and did. Well, that changes things, doesn't it? Defendant was provided sufficient time to and did make a knowing, voluntary, and intelligent decision not to testify. In denying defendant's other allegations, the court relies on the complete trial record in the proceedings. It is therefore ordered and adjudged the defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal are denied. So at the end of the 57-page court order denying all of the defendant's motions for things, the court brought the receipts, timeline, literally screenshots, transcripts, fucking everything.
Receipts, proof, timeline, screenshots, everything.
And went through not only Donna Adelson's request to interview the jurors and said denied. The court set out the standard for that, which clearly was not met by the defense motion. The court also went the extra step of saying, not only did I look at the TikTok they complained about, it is still on the jurors' TikTok account, and nothing in that TikTok is outside of what I told the jurors. And just so that we're clear, here is the transcript from jury selection where I said jurors are allowed to tell those that need to know where they are, that they have been selected for jury service, and how long they will be on jury service, and what is in that TikTok about the case. I've been selected to be a juror on a 2-week case. And the court said that falls squarely in line with what I told them to do. And then remember that the defense was arguing that Donna did not have enough time to make her decision about whether or not she would testify. And I said repeatedly, look, this is something they're going to bring up on appeal. The court's aware of that too. And do you know what he did? Oh, he went in real time in his ruling and then in the transcripts, moment by moment, talking about every time they discussed how much time the defense had to discuss these things with Donna. He pointed out, not only did they not need to discuss further evidence because Donna sat in court day in and day out and watched it in real time, but they highlighted that they talked to Donna before this case even started about whether she would testify. They talked to Donna over the 3-day weekend on Saturday and Sunday about whether she would testify. On Tuesday, court broke early in trial so that they could what? Talk to Donna. And then on the day they were deciding this, they took an extended lunch so that the defense could talk to Donna. And then you get to the end of the day and Donna's like, Your Honor, I'm not ready to make that decision. But what we learn is that at sidebar, Donna, in her own words, was complaining to the judge that she needed more time to talk to her lawyers and 5 minutes isn't going to cut it. Verbatim what's in the transcript. So then we see the sidebar transcripts of Donna's conversations with the court. And when the court is just literally laying down the law of we need a decision on this, Donna's like, can I say something? And the court's like, talk to your lawyer. And then when Attorney Fulford is cutting off the court's like, excuse me, I'm speaking. What? And then the court included the excerpt of when the court was talking about contempt for the defense being given time and not being ready in that period of time. And then the court sitting on the bench saying, we need an answer. I'm not talking just to talk, which was a moment in that entire day of court that just blew my mind.
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on.
The court's on the bench. Court is in session and they're just ignoring the judge who's like, do we have a decision? We need an answer. It's kind of wild to revisit it in context of all the sidebars because you can see the building of how frustrated the court was and how patient the court continued to be and how frankly restrained the court was in his comments to the defense. I don't know if they caught the court's facial expressions when the court was literally in real time going, I'm not just talking. Why are you not answering? And do we need to talk about contempt? Because this keeps happening. And it was not the first time it came up. It came up in sidebar after sidebar after sidebar because the judge gave us a compendium of sidebars in his ruling. And the transcripts included with that ruling is what took up a substantial amount of that time. The court was like, let me tell the appellate court everything. Let me just make sure the appellate court is clear where I stand on this issue. Here are all of the transcripts. Here is all of the time we discussed this. We're done. And of course, all of those motions were denied. But really, we knew that that was going to be the result. We knew the result would be that those motions were denied. I didn't know the journey would be quite so wild. We need all the sidebars. Donna just chatting with the court was wild. But do we expect anything less from Donna, thinking that somehow she is going to be treated more specially special than anyone else? The court kept saying, you are in no different position than any other defendant. Every defendant that comes before this court is treated the same. And you are in the position that they are all in. Decide. It is time. Oh, Judge Everett's sass just came through all the way. And Judge Everett took the time to quote an appellate court opinion that said, we are not voyaging on a sea of hearsay, which 10 out of 10. The voyage on the sea of hearsay is just so incredible. I am always here for Judge Everett. I am here for Judge Everett's sass. If there is another case that comes before Judge Everett, whether it's connected to the Adelsons or not, I'm going to be very tempted. The patients are 10 out of 10. The judicial demeanor is great, but also the writing. I appreciate the wit and the sass, but also the directness We're not fucking around. And it's all backed up with, of course, case law. It's really nice to see linear judicial decision making. It's fantastic. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.